Welcome to today's Explainer. We are jumping right into a real-world legal mystery about property damage that could, honestly, happen to literally any of us. We're looking at a fascinating case from 2012 involving the Ciento Condominiums Homeowners Association. You know, if you've ever lived in an apartment or a condo, you totally understand that your peace of mind is often only as solid as the floorboards right above your head. Today, we're going to find out exactly what happens, legally speaking, when those floorboards give way to a literal flood of problems. So let's dive into this incredibly relatable nightmare scenario. Picture this. You're chilling in your living room, totally minding your own business, when suddenly, water just starts pouring through your ceiling. Your upstairs neighbor is at a massive plumbing failure. Your stuff is soaked, your drywall is completely crumbling, and you just know the repair bill is going to be astronomical. Now, you pay your monthly HOA dues faithfully, right? So naturally, you'd expect the HOA to step in, fix the mess, and hold that upstairs owner accountable. Well, the case of Dr. Martin W. Johnson versus the Ciento Condominiums HOA tests exactly that assumption. Let's see who's actually on the hook. To really grasp the sheer gravity of this case, we have to look at the price tag. Almost $23,000. This was not just a minor drip that needed a quick patch and a fresh coat of paint. The water damage to Dr. Johnson's downstairs unit, Unit 117E, was catastrophic. His homeowner's insurance company had to step in and pay nearly $23,000 to contractors just to make the place livable again. When we're talking about property disputes, these are serious financial stakes. And this massive payout instantly validates why Dr. Johnson fought so incredibly hard for accountability.
And the financial hit was only part of the nightmare. We're talking about half a year of construction here. Imagine your own home being an active construction zone for 5 whole months. That would test the patience of absolutely anyone. Plus, on top of that massive inconvenience, Dr. Johnson was forced to pay a $500 deductible right out of his own pocket for damage he literally didn't even cause. This human toll, this sheer frustration, is the whole driving force behind the legal battle. Dr. Johnson felt completely wronged, and he was convinced the HOA board had a legal obligation to repair the damage and backcharge the guy living above him.
Now, you might be thinking this was just some freak one-time accident. Nope. It turned into an absolute comedy of errors. Let's track how this escalated. The downstairs unit suffered water damage 4 separate times from the tenant above. In September 2009, a broken toilet causes that massive $22,000 loss we just talked about. Fast forward, renovations finish up, and then in May 2010, bam! Water comes down again, this time from a busted kitchen drain. Then, in September 2011, another clogged toilet wrecks Dr. Johnson's bathroom. And incredibly, in January 2012, an overflowing bathroom ruins his ceiling all over again. And get this, the unit above was owned by a Mr. Kenneth Hamby Jr., who, astonishingly, also happened to be the treasurer of the HOA board. No way, right?
And this wasn't some mysterious slow drip hidden behind the walls. Oh no. Just listen to the visceral, physical reality of the damage straight from the plumber who responded to the very first incident. The property manager sent this plumber out, and he finds the upstairs toilet completely clogged with debris. The handle and flapper were broken, meaning the water just wouldn't stop running. He noted it had been flooding over for quite some time. They actually had to lug in a commercial water extractor just to suck up the standing water. Hearing that level of negligence makes Dr. Johnson's absolute frustration make complete sense.
So here is where we hit the core conflict. On one side, you have an incredibly frustrated downstairs resident demanding the board do something. He formally petitions the state, arguing the HOA bylaws explicitly give the board the power to repair the damage and bill the at-fault owner. But on the other side, the Ciento HOA draws a massive line in the sand. Their defense was basically, look, we can't vet tenants, we aren't a police agency, and legally, we simply cannot force Mr. Hamby to pay you. They viewed the whole mess strictly as a private, neighbor-to-neighbor dispute. So, Dr. Johnson tries to handle this directly. He sends Mr. Hamby multiple letters with statements of loss, just begging for reimbursement. And after being completely ignored, he sends a final, formal demand. Mr. Hamby's response? A firm, written denial. He completely rejects any responsibility, claiming there's no evidence of his own direct negligence, and essentially slams the door in Dr. Johnson's face. So, with the upstairs owner flat out refusing to pay and the HOA washing their hands of it, Dr. Johnson really has no choice but to escalate this legally to an administrative law judge.
All right, so how do we actually solve this mystery? Well, we have to bust out the rulebook. We're talking about the CC&Rs, the covenants, conditions, and restrictions. These are basically the governing laws of condominium living. When you buy into an HOA, you are agreeing to be bound by these exact documents. They are the ultimate authority. In a legal proceeding like this, it honestly doesn't matter what feels fair or what seems morally right. The judge's entire job is just to look at these specific legally binding documents and figure out, did the HOA actually break its own rules by refusing to help Dr. Johnson?
And boom, we don't have to look very far to find our smoking gun. Right here is the exact clause that completely limits the HOA's power in neighbor disputes. Article 12, Section 5 of their CC&Rs explicitly states that the association has absolutely zero responsibility for resolving disputes between owners. That explicitly includes claims for damage to the property of one owner caused by the acts of another. Now, Dr. Johnson did point to another section saying the HOA could repair damage and charge an owner, but the judge pointed out a crucial detail. Because Dr. Johnson's own insurance company had already stepped in and fixed the unit, the HOA was never actually put in a position where they had to undertake those repairs themselves.
But wait, it goes even further. The community rules are super explicit about plumbing. Under Article 2, Section 8, maintaining the plumbing inside a unit is entirely on the resident, not the association. Residents have to maintain their toilets and bathtubs and make sure they don't clog up and ruin the day of the person living below them. This completely shatters any argument that the HOA was somehow negligent in maintaining the building's overall infrastructure. The plumbing that failed was inside the unit, so under the rules, Mr. Hamby, as the owner, was solely responsible for maintaining it, whether he lived there or rented it out.
Okay, so let's break down exactly where the liability lands when the dust, or in this case the water, settles. It's actually pretty clear. You've got Dr. Johnson, who unfortunately took the physical and financial hit with that deductible and who filed the petition. Then you have Mr. Hamby, who's undeniably legally responsible for the plumbing in his unit that caused all this chaos. And finally, the Ciento HOA, who, despite Dr. Johnson's totally understandable anger, simply has no legal jurisdiction to get involved in owner-to-owner property damage claims. So, after looking at all the evidence, Administrative Law Judge Sandra J. Vanella delivered her final findings. And the verdict? While the situation was undeniably awful, the HOA was legally entirely in the clear. Dr. Johnson simply didn't prove that the HOA violated any of its bylaws or CC&Rs. At the end of the day, this dispute fundamentally lies between Dr. Johnson and his upstairs neighbor. Now, the judge did make sure to note that Dr. Johnson can still absolutely sue Mr. Hamby in a regular court of law, but as far as the HOA is concerned, they don't have to play middleman. The petition against the HOA was officially dismissed.
As we wrap up today's explainer, I really want to leave you with this thought. Seriously, take 10 minutes today and check your own paperwork, because you never know when the ceiling might literally fall in. This case is just such a brilliant reminder of the massive gap between what we expect our HOAs to handle and what they are actually legally required to do. Dr. Johnson learned the incredibly hard way that an HOA is not some magical shield against a terrible neighbor. Understanding your CC&Rs before disaster strikes is pretty much the only way to protect yourself. So I gotta ask you, if disaster strikes your home tonight, who are you legally allowed to hold accountable?